We are a community working towards empowering children and young adults with autism and special needs to be independent and help them integrate better in a social setup. We have online parent forums, panel discussions, and curate new experiences, be it a day trek, festival celebrations, our flagship musical event, #Unlabel, and more. We recently launched the Dads Club on Father's Day and a youth club focusing on online socials for youngsters by engaging with college volunteers. We strongly believe in the community coming together and would love for you to be a part of our community. Do look us up on mitraforlife.org for more details. Now, it is my pleasure to welcome today's guest, Mr. Sriram Narayan, Managing Trustee of the Amaze Charitable Trust, Coimbatore. Mr. Sriram is a management consultant and is also a special dad to 25-year-old Nishant, who is an energetic and vibrant individual. Mr. Sriram is a chartered accountant who now does business process consulting. He has conducted several webinars on the need for legal and organizational structures for individuals and businesses. Today, he will be talking to us about planning guardianship for a child with special needs. Welcome to this evening, sir. Over to you now.
You're muted, sir. You're muted.
Thank you, Samyukta. Thank you, Mitra for Life, Arpita, Madhavi. And yes, sorry, I pronounced it wrong, Madhavi, Dr. Madhavi. Thank you. And thank you for giving me this opportunity. I mean, it's always a pleasure to talk to parents of special needs kids, and being one myself. I mean, our journey through and whatever we have discovered, we sharing it. There's nothing stopping us from sharing it. Of course, we do. And moving along. So what I am going to do today is that I'm not going to go through the process of how to create guardianship, but instead I want to give an indication as to what are the need for a guardianship. Now, facts of guardianship. Okay. First of all, there's a little bit of history involved over here. I mean, the first time there was something called as a time in 1890 or some, around that time, an act was passed in India called the Guardians and Wards Act. And this was primarily decided to protect the minors. Now, this act came into being at that point of time, so that any minor, I mean, there were a lot of children who were losing their parents due to various things. So who will look after the minors, etc. So this particular legal law came in at that particular time, and they, in that particular act, I'm sorry, I have not mentioned about this particular act because that's something you just need to be aware of. Nothing very much for just for your information rather than for understanding. Now, for a long time, so who could be appointed and how could it people be appointed under the Guardianship Act, and when does it come into being? I mean, it came into being, actually, it said that, okay, it will come into being specifically for a minor and also for anybody and over the age of 18 until they attain the age of majority. Okay, so because the reason why it came into being at that time is that it was felt that underage people who are under the age of majority, under 18 years old, a person is not competent to make any decisions for themselves or sign any contract on behalf of the thing. That was the reason for which the minors were needed to be provided with a legal guardian if the parents were not around. Okay, so now what happened was that in 1990, that's about 100 years later, okay, we realized that a PWD, especially a PWD with intellectual disorder, is also in the same state as the minor. Only thing is that there's no age bar. It is beyond 18 years. Yeah. So, and we still feel that a person, I mean, is not competent to make any legal decision. The person who is affected by an intellectual disorder. Now, what was an intellectual disorder? It was not around 1990. It was not defined under the PWD Act. Okay, and it only said talked about mental retardation and they stopped with that. But all the physical disabilities were listed. So National Trust Act came into being at that point of time to include autism, cerebral palsy, and Down syndrome as disorders to be taken care of. And they also, under the National Trust Act, the complete rules and regulations of how a guardian um, can be appointed, who can be appointed a guardian, and also the complete procedure for the country. It's a central act, so it is applicable all over the country, and it's been laid down. Actually, you can Google National Trust Act and then learn far more about it. I mean, it's a very easy, a lot of things, and it's put in very simple language, fortunately. Okay, but the National Trust Act is also available in Google. It takes a little more of a legal language. So if you have the appetite to swallow legal words and legal sentences, well, that's also an option. Okay, ideally, most of us, I mean, professionals, especially people like me, I mean, we always turn towards the legal act and try to decipher what is there. But always there is a certain amount of ambiguity over there, and which is again put across different while in practice. Okay, so whatever I'm going to share with you over here is a mixture of what I have seen in the Act and what is also seen in the National Trust website. So typically, legal decisions. What do you mean by legal decisions? I mean, as far as we are concerned, okay, as long as my child is able to look after himself, have a bath, go to the bus stand, go to the shop, I mean, exchange money, I mean, we think he is independent. Okay, well, that is more than that. I mean, what they actually talk about is that they should be in a position to enter into, especially asset ownership. Suppose the parents or grandparents or somebody leaves behind a fairly large chunk of assets in the name of this particular child, or you want to leave behind anything in the name. Now, there are contracts, the purchase or they want to sell it for the benefit. Now, the purchase and sales contracts have to be signed, and it will not be acceptable if the person directly is able to sign, because if he holds a disability certificate, especially a intellectual disability certificate. Okay. Another one is that investment and deposit of applications and insurance policies and claims. Okay. There are many more such things, which are all legal documents. These are just examples which I have. Now, before I proceed further, I mean, I just want to let you know that, okay, now this becomes a big necessity. Guardianship becomes a big necessity once the parents, after the demise of the parents. Of course, it is there during the demise of during the life of the parents also. I mean, a person, a PWD above the age of 18 years is considered a major, and the parents can take, but many of the time, I think we parents are always there available, and we take decisions. We decide what is to be put in his name. I mean, be a joint account holder, etc. All those things, I mean, whether a particular asset should be in his name, should be included. Since we take the decisions, I mean, it doesn't have a very significant role, but post our passing, our demise, post our life, when he or she is alone, at that point of time, a legal guardian will become a necessity at that point of time. Okay. Now, so there was, like I told you, that the National Trust Act actually came into being in the year 1990, around the 1990 or so, or plus or minus, you can say about 2 to 3 years. But prior to that, how was a guardian appointed? A guardian was appointed by a will. I mean, so the person who was dying used to write a will and then say that XYZ will be the guardian for my child who is this particular, who is in the, who holds this kind of a with an ID, etc. That's another. Okay. Assuming the will does not mention anything about a guardian, or the parents leave, or the parents do not leave any will behind. Okay, the court comes into. Now, why will the court come at all come into the picture? Okay, primarily they believe that since these persons, PWDs, are not competent to make any decisions, especially if they are holding fair amount of assets in their name. So the court will appoint directly a person under his as a guardian, and by passing an order with or without the will, and then thereafter the person who has been appointed by the court will act on behalf of the guardian. Now, post the National Trust Act in 1990, guardian can be appointed during the lifetime of the parents itself, and there is a procedure for it. Okay, there's a procedure which has been laid down under the. So this is where National Trust comes into being. Okay, now National Trust, this is one of the major things which National Trust brought about as far as guardianship things was concerned, because nowhere else was it specifically stated with respect to how do we appoint and whom do we appoint, what are the process, etc., for a guardian or guardianship under various other acts. I mean, even now, the appointment by will and then appointment by court still exists. I mean, it's not that it is totally out, because the Guardianship and Wards Act continues to exist. The Indian Majority Act continues to exist. So obviously you can put up a petition to the court based upon under those acts and then get the respective guardianship still. But this makes it a little more easier on us as parents. Okay, now diverging a little bit as to who are considered as a guardian, legal guardians. Natural guardians are parents, either singly or jointly until the child reaches the age of maturity or 18 years. But with respect to special children, it will be the same. Now, singly or jointly, I mean, typically it will be jointly, but singly means only when one parent is in case of a divorce or a separation, or in case of death of one of the parents, then that is allowed. That person is a guardian. Okay. And by default, we all become guardians. Then I think I've talked about it, guardian appointed by the court, and then the testamentary guardian. However, in any application to the court, or whether it is by will or without the will, the court takes a decision. How does the court decide whether who will be the best person, who will be the guardian, and how is it? Now, primarily, the way the court looks at it is, the judge who passes the order looks at it is that, will this person, what is the amount of care required for this person, and what are the assets which this person holds, which will need to be protected, and who else is available to take up this guardianship. And based upon all these things, who else means they're talking about relatives, siblings, or any other thing. And based upon all those facts which is produced in front of him, and if it's in the petition, if it is given specifically that there is nobody else, and if the judge is satisfied that there is nobody else who is available, the judge passes the order to appoint, and sometimes they will appoint their own person also to be a guardian. Now, after the National Trust Act, I mean, they have also said that they may appoint a person under the National Trust Act to be the guardian. Now, the question is, in these cases, it's a little risky, because this is where we don't know who is going to be appointed as a guardian. We don't know whether the assets will be protected. We don't know if the child will be taken care of in the way they need to be taken care of for their needs. Especially we are talking about the financial needs, residential needs, etc. I mean, whether all that specific care will that be given. Obviously, we cannot give the same amount of, nobody will be able to replace the care which a parent gives. Okay. But it's very much important that the other person, the person who is going to be giving that care, is at least, capable of, is competent of giving this particular care. I mean, they're not into debts, or they're not having it, they're not insolvent, they're not mentally unstable, etc. Those are the factors which the court will specifically look into before appointing. Okay. Now coming back, that was a little bit of a digression into the thing. Now we are coming back into what is the National Trust Act. Now there is a particular section called the Section 14. There are two things which is involved over here for the process of guardianship. One is an application will have to be made to the under the National Trust Act, and also there are certain persons whom the National Trust Act has identified who will be the guardians. So I mean, that's what who can be appointed as guardians, and that's what I'm going to cover in the next two slides. Okay, so if you read this, I mean, basically it goes like this: like a parent of a person with a disability or his relative may make an application to the local level committee. This is what is the local level committee is being appointed by the National Trust Act for appointment of any person of his choice to act as a guardian of the persons with disability. So a parent or a relative can make an application for guardianship. Another one, who else can make an application? Any registered organization. I looked through, went a little more, explored a little bit exactly what exactly. I mean, finally, I think I realized that though they say registered organization under any act, I think it is like a registered organization under the National Trust Act is what they would look at specifically. So any registered organization can make an application to the local level committee for appointment of a guardian of a person with disability. So while considering the application for appointment of guardian, the local level committee will consider whether the person with a disability needs a guardian. Okay, that's the first one. And the second one, the purposes for which the guardianship is required for the person with disability. Okay, now the purposes could be like for a residential care, for looking after the movable assets, for looking after the immovable assets, various things. There are various options which is available. If it is in the application, you can pick a few of those options, whichever option is applicable, and based upon that. Okay. Now, I looked at now who can be considered for guardianship. Though the act is not very clear about it, but there are some indicators on the National Trust Act Trust site as to whom the National Trust would consider to be appointed based upon the application. So, yeah, right now, even at this point of time, parents of the PWD, either jointly or singly, you can apply directly during your lifetime. And siblings, either jointly or singly. Okay. Now they also say that suppose it is the siblings of the PWD. Please understand these are all in relationship to the PWD. I mean, so that is where it comes. Any relative of the PWD, that is direct lineal relative, is something which they look at. I mean, direct uncle, aunt, that is, for example, my sisters would be considered as a relative for my son. Okay. So also my wife's sister would be considered as a relative of my son, right? Okay. And that is a primary or a brother or etc. But my third cousin, I don't think so. Okay. So let's be very clear on that. But I can, as a parent, I can appoint that particular person and then I can make an application for that person. Okay. And or that's where it comes as any other person. I mean, any other person, that's what they're trying to say, is that any person whom the current guardian, okay, that is the current guardian, the natural guardian, or anybody who can also appoint, that is typically the parents can make an application for another one of these people or any registered organization. Okay, now this also means is that suppose I as a parent want to apply for a guardianship as for myself, guardianship for my son, and the guardian is myself. That is allowed. But in addition to that, I am also allowed to specify either my daughter as a guardian, okay, for my son, or any other relative or any other person whom I consider, or any registered organization. Okay, I can do that right now and get the guardianship certificate. Now, one of the conditions which they have also said, this is again not anywhere mentioned in the act, but I think it's been put into practice. Okay, so it's available on this is what is put out in the National Trust site, that the guardian, whoever has been appointed, must live in the close vicinity of the PWD. Okay, that's one of the key things. And another thing is that they're very clear that a single male cannot be appointed as a guardian for a female. Okay, but a male and a female, a couple, can be appointed provided the female is the primary guardian of the female. Okay, this is what was one clarification. I think this comes from the missing of protecting the females or women PWDs, protecting them, giving them a kind of a protection from additional abuse. So this is where it comes. Yeah, so this is where lastly, this is a local level committee. So actually National Trust Act, appoints local level committee in various districts of the country, has appointed various districts, and these local level committees are in charge of getting the process of the guardianship complete. Now, with this, I come to the end of my presentation. First, thank you very much for listening. Sorry, it's been, it's a very short topic, but a very important topic. So I leave that now. Now I am open to I thought like I would spend a little more time with respect to questions with respect to on this in case you can. Yeah.
Yeah, please go ahead, Mr. Shudipta Maiti. Please unmute yourself and ask. You are muted, sir. You're muted. You're muted.
Just a moment. We'll enable people unmuting themselves.
Okay.
Just Yes, it should be available now.
Okay. Yeah, I could not unmute myself. So thank you very much, Mr. Narayan, for this very informative thing. I have one question. Can a foreign citizen be a guardian?
No, I think because see, the guardian should be living in the vicinity of the PWD.
Even if it's a sibling, that has to be true, is it? That person should be living in the vicinity?
Yes, I mean, I think at the time of application, what they look at is that when I talked to some one or two people who had this, but they said that they made at the time of application, they presented both the Aadhaar card of that uncle. It was an uncle who was applying, and for his nephew, both of them, the nephew Aadhaar card had the same address, so they didn't seem to be any questions with respect to that. Okay, I see a question here. Is that okay, Mr. Sudhir?
Yeah, that clarifies it. Thank you.
See, it's everything is a little ambiguous. I mean, only once you get into it that things a little become clearer. And it's specifically like, again, it's again very district or the state control. Like in certain practices are different in certain places. I mean, those are all things which it's very difficult to answer. But broadly, this is what the Act says, and this is what National Trust has been put across. Okay, so ideally, it would be better to do that. Yeah, yeah. Okay, somebody raised a hand. Yeah,
Can I speak?
yeah, please.
Yeah, yes, yes.
Yeah, I'm Chari. I'm Mrs. Chari. I stay in Kovai, Chinmayam.
Hi, Mrs. Chari. Yeah, lovely to
Yeah.
meet and see you in person and virtually now. Yeah.
Yeah, the thing is, I have the guardianship certificate for my daughter with cerebral palsy.
Uh-huh.
As natural guardians at the local level committee here, I was in Mumbai earlier.
Uh-huh.
I applied through Jaivakil, and then they said the parents, only the parents, whenever they are alive, as long as they are alive, will be the first guardian for the PWD. So
Okay.
it was acceptable. At that time, I did ask them if one of the parent, my husband was abroad for quite some time. I said, can I make the sibling, that is my son, as a joint guardian with me? They said, no. When the parents are alive, whenever he's down, you come here and then we will do it for you. And that is how it has been done. I'm wondering if one of us not being there in the event that one of us not being there, can sibling who is not in India, he is abroad, can he be he has an Aadhaar card over here and everything. I did ask them in his life, my husband said, in my lifetime itself, why don't you make him the guardian for the PWD? So I don't know whether they allow it now when the parents are alive. If the parents, when the parents are alive, the local level committee insisted only the parents can be legal guardians, even when my son was around. So I was, and then they said, if the sibling is married, he should get a no objection from his spouse and then do it. That was the law 10 years ago.
Yeah.
I am told by somebody that the sibling can also be, or anybody else can also be a guardian along jointly with one of the parent. So I would like to have one of the parent and the sibling so that it is an easy, people, there'll be a easy, sail through, once the parent goes away, the other guardian is still there to take care, the younger person. So
correct.
So is there any ambiguity in the law, or can it be can we apply now in spite of the parents being alive?
I think it's better to try, because when I spoke to somebody here in Tamil Nadu, Coimbatore, especially here, that's Vidya Vikasan, they said that whoever you put in the application, and as long as you file it along with the photographs and the Aadhaar card of the person together, I mean, they look into it and they already issue it. Because see, the objective of this legal guardian is that, okay, not only, I mean, it's like, okay, legal guardian is actually replacing you, and so in their lifetime, so they are very concerned about where the legal guardian is going to be living. Okay. Yeah. And see, anything happens that legal guardian has to give certain certifications. Say a very simple thing, even if it comes to a medical procedure, I mean, it could be a general, they will ask they typically ask for a parent's consent. So in this case, they will turn to a guardian. I mean, who's the legal guardian if the parents are not? Okay. So the objective is this, but I think it's worth trying once again. I mean, I think it's from my understanding of this particular act, it's because of it's again practices which are in various places. Now, that's something which I'm not able to comment upon, because I hear different stories, I mean, from different places.
Okay, because my Aadhaar is having Mumbai address. So can I go to Coimbatore and then check with that local level committee, or I have to do it over here itself?
Now, I think you first change your Aadhaar, change the Aadhaar address on the Aadhaar if you can.
I have too many things to change in that case. And
Yeah,
passport and everything. So that is such a huge issue for me since I have something in Bombay also. I'm still continuing to hold on to my
yeah,
address. So that's the problem. So
yeah.
this can
I
be done.
understand.
And can I add with one parent, I can add my niece who's willing to be a guardian along with the sibling?
No, no, no. That's what they say. They say that parents or both parents,
Ah,
if not, then the siblings, then the next person. I mean, I think
one sibling.
parent and sibling, one parent and one sibling, I don't, it's not there. They're not going to give it. Unless
They
the
won't.
parents are no more, then it comes to the sibling. That's how the thing goes. And then
That's
after
what
that,
we wanted. Then they said if one parent goes away, the sibling can come in.
yeah.
That's what only at that point in time the sibling can come in. I don't know what is there in Coimbatore in
Yeah, I will have to check it out because from what I understood from here is that, yeah, even the, like, see, what they say is that if the parent or anybody is not around, suppose there have been the person whom I spoke to over here said that, see, the parent wants they put their child in an institution. They want the child to take the guardianship. Okay, we don't want to be this. So they have gone and registered the guardianship as that organization as the guardian for the child during their lifetime. So I am applying the same logic. Applying the same logic. I mean, I don't see. I think it should be possible. But again, you need to go forth up and down. Yes, that is required.
Thank
Can I
you.
ask transition?
Yeah, I think we'll give the others a chance, ma'am.
Yeah. There are a few questions in the chat box also. Like, what do you mean by?
We've just highlighted Mr. Ashok Shah. Please, he had raised his hand. We'll just finish 2 questions with the raised hand. Yes, sir. Please go ahead.
Can I come in?
Yeah, please.
Yeah. Good evening, sir.
Good evening. Hi, how are you doing?
2 things. One, I think you did not touch up the issue of confusion between the guardianship and the trustee.
Okay.
Still exists a lot of ambiguity in that area. Second thing is, for my son, when I applied for this thing, they said that for what purpose of the guardianship required. One is to take care of the child. Second is to take care of movable asset, and third is to take care of immovable asset. Now the certain investment in his name is there. Immovable asset, he is a nominee right now. So can immovable asset also be included for the guardianship care?
Okay, let me take up one by one. I take up the last question with respect to the immovable asset in which he is a nominee.
Right.
Okay. Now, the need for a nominee is more like a person who is like a executor to a will. I mean, they don't own it directly. They are, in case of your death or anybody else's death, that person who is named as a nominee has a right in disposing that particular asset, but doesn't become the direct owner of that particular asset unless it is specifically stated in the will. Okay. Yeah, that is when it takes over. Okay. So a legal owner gets ownership, or a nominee gets ownership only when it is directly put up. Now, another thing is the nominee is that the nominee can do whatever they need to do based upon what the person who passed away, who created them as a nominee, what directives they had given with respect to that particular asset. So this is my answer to the question. I mean, with respect to the nominee. Now, since you put your son as a nominee, okay, I'm not too sure whether it's more like a name which has been put over there. But in order to protect yourself completely, I think it's better to bring that particular asset under put that or specify it in the will that this person will become the owner of the asset to whatever percentage, etc. This is my advice to you, because this could come up with a lot of questions. Just being a nominee, and moreover, plus he's a PW. right? Okay.
Issue is like we have no other option but to put his name in the name.
Yeah, that's okay.
And second thing is, I think then in that case, person with disability will be, it's illegal to put him as a nominee. Is it that? Or he's
Not
not eligible
illegal. He's
or
not
he's not
competent.
eligible.
He's not competent. Yeah, he's not eligible. I think that is a better word. He wouldn't be an eligible. Under the eyes of law, he would not be eligible to be the nominee. So to add to it, now that it is done, I mean, you can't do anything about it. But then what you can give an additional protection is to include it in the will that this particular asset, this person would be the owner of this particular asset, though he's been identified as a nominee. So that gives the additional protection to ensure that the asset goes to him directly. Okay. Now coming to the question with respect to I think trust and trustee and a guardian. Well, a trustee, that's something I didn't touch upon. I mean, thanks for pointing out, Dr. Shah. Now, trustee is a person. I mean, basically, what has been advised by everybody is that, okay, National Trust Act talks about, have a guardian and all that who will take care of everything, who will ensure that. But specifically, if you want additional protection, specifically with respect to financial assets, which you are going to leave behind in the name, you form a beneficiary trust in the name of your child. And you appoint one person who as a trustee to that thing. Now, that person can be the same person as the legal guardian, or it can be a different person also. Okay. Other than that, now legal guardian is only going to be the legal face, but a trustee is going to be taking care of all the assets which are under in the name of the beneficiary trust for your child, and the trustee will have certain specific rules which is specified in the trust deed. What should be done with that particular asset? Should a fixed deposit? Should it be renewed? What should it be paid for? What does this particular trust exist for? I mean, to pay for his expenses, to pay for his long-term education, or to pay for any other, to take additional listings or anything else, you can specify it in that. And the trustee will ensure that it is carried out accordingly. That is the reason why we have a private trust. And any monies taken out, if at all taken out by the trustee from this beneficiary trust, I think it cannot be taken out under his name, because this private trust, you can also ensure that it is the private trust pays gets a PAN number and is also audited by an auditor for every year. So in that case, to that you're giving additional protection to that particular. Yeah. Okay. Now, so I think I've answered both the questions, right? Okay. So anybody? No, I just want to. There have been. I mean, as I keep talking, the questions just keep pouring in.
Yeah, a lot of questions on the chat box.
On the chat box, right? Okay,
Yeah,
let me just go work. Can you please give permission to record this?
Close vicinity, they want to ask what exactly is close vicinity? Same city or nearby area?
I would think yes, same city.
Same city.
This is my understanding, but again, it's up to the person who is actually approving the legal guardianship certificate. I mean, what they think about it. But I think same city makes a lot of sense, common sense. That aspect.
And is UDID card mandatory for applying for guardianship?
See, UDID card is a certificate which is disability certificate. It's like a ID which is specifying the disability. And compulsory, again, it is depending upon the practices, because currently, of course, the UDID has become the standard identity card for everybody. So I would think that, yes, that is something which needs to be attached. So otherwise, how will the person, how do you identify that this person is a person with a disability? Okay, because one of the key things for guardianship is that the person should have a disability, right? Okay, so I would think that you should have it as a mandatory available, or any other district disability certificate if the authorities are okay. It is okay. There was one from. Is that okay? I mean, it is only for Prabha and Suresh. It is only for purposes of smooth transition. It would help if one parent and a sibling can be made guardian. Sir, I don't know it again. It is again the one side is the law, and the other side is the execution of the law. So both are two different elements and how they function. So it's a question. I really don't know how we can go through it. From what I read and what I have seen, this is what I can say. Whether a parent and a sibling can be made a guardian, of course, it doesn't specify specifically. Jointly, they say only the parents, or jointly the siblings, or any other relative. I mean, that's what they specifically say. So it's a question of, I mean, we just leave it at that. Next question is guardianship certain. In the guardianship, it mentions first guardian is one parent, another parent is second guardian. Can we add another person as second guardian instead of a parent? I think I've answered it in the previous thing. I mean, it's a question of, yeah, it is either both parents or how do we go about making a trust? Can you cover that? I wish I could cover. I wish I had enough time on that. I mean, that's another topic by itself as to what we need in that as a private trust and what are the things which we need to look at it. We'll do that as another on a separate. Good evening. I'm Mohammed Kachwala. I have two questions. Is Swavlamban card compulsory if PWD is in the property as a joint holder? Okay. What I read from this is a Swavlamban card, I think, is mainly for the medical benefits. So I don't think that has got any relationship with that. I think here what they're looking at is that basic ID is a Aadhaar card, and I think a disability certificate, disability card specifically on that. PWD is in the property as a joint holder. Okay, so yeah, he is in the property as he may be named as a person of the joint holder, and then because there is also another, it's like a joint account. Think about it as a joint account. My son is holds a joint account with me. I mean, so whether he can sign on anything, I mean, primarily both any decisions to be taken on the property, all the owners have to sign on that particular legal document. So he becomes a joint holder. But what happens if one of the joint holders passes away? Then the question comes as, can the PWD hold the property in his name? And that is when the issues will arise as to he as a person is not eligible to hold a property in his name directly. Okay, only through a guardian he will be able to hold it in his name or through a trust. Yeah, so that is what the law is. I'm not sure what you're trying to ask in this particular question, but I think this is what I thought. I mean, if Mohammed Kachwala is there, maybe he can speak up. Yeah, or if I have answered the question, you can go ahead.
The awareness about guardianship is still not gone far and wide. It's like to a limited portion only. So, I mean, any awareness drive or something like that, like UDID card, we have made it mandatory. So something like that, so that it is, more popular, people are more aware of it. Because people whom I know, many of them are not aware, not ready. So.
Well, we have to organize, I mean, I'm thankful since seminars like these, we'll have to organize it more frequently. And to more people, this is what which comes to my mind immediately. And it would be, I mean, we are covering only a very small section of the population, and that too only in a very specific area. I mean, more number of places, such things are made aware. I mean, that's how the awareness spread. Well, see, I only look at it as to what we can do, and then this is all we can do about it. As much as possible, we can create that thing of spreading the message around various people. beyond that, it's not in our hands,
We
right?
need to, because it is not that popular and people are
Yeah,
not aware about
that's a good point. Yeah, I agree on that.
it. Any questions? There are a lot of
Yes,
questions.
Yeah,
Can I
just a
ask a
moment,
question,
Arpita.
please?
Yeah,
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 yeah, sure.
yes, please go.
So I had typed this, but thanks for the opportunity. First of all, Mr. Narayan, thank you for taking the time and the trouble to walk us through this. It was very informative. My question is, after you said that the parents are will be treated as the natural guardians and they'll have to apply for it. After the demise of the parents, how can the guardianship be transferred to the living sibling of the PWD? Is it via a will? Will that will have to be made by the parents while they're alive? Or if suppose they fail to make that will and after their demise, does the court legally recognize the sibling as the next guardian? How does that process work?
see, when you, I'm applying total common sense over here, and in the process of this thing, you can see in my, I'll just go back to my slides for a minute. There's a distinction between who can apply for a guardian versus who can be considered for guardianship. Okay.
Correct.
Yeah. Now, in the place where there's an application for a guardian, it says that a parent of a person with disability or his relative may make an application. The relative is very far and wide, and hence they have made it a little more. They say that okay, siblings or any other relative. Okay. Now, my understanding or my reading of this is that okay, if today the guardian, you take the guardianship, you are appointed as your name is there as, or you and your wife's name is there in the guardian, in the guardianship certificate. Now, in order to ensure that it moves on to the sibling of the PWD, I would suggest that you put it down into the, write it down into the will that this person will be appointed as a, it will take over as a guardian and can apply for guardianship under the National Trust Act. So now that person has got the ammunition to go forward and make the application. The sibling can take the application with your, along with your will, and make the application and get the guardianship transferred into that.
Got it.
Okay. This is,
thank you, sir.
This is like just applying common sense and the various aspects. Typically, this is how they should function. But again, God forbid, I mean, there are always cranks around the place. Correct. So we don't know where things go.
Sure. I have one more question, if you'll permit me.
Sure.
I'm sorry if it's a very elementary question, but till what age is guardianship needed for PWDs? Is it lifelong? Or does the legal system allow them to be off a guardianship beyond a certain age?
No, it's lifelong. See, it's lifelong because it's the same example. Like the law doesn't recognize that they are eligible to make any legal decisions on their own.
Okay.
Especially people affected with autism, cerebral palsy.
Okay. Thank you very much, sir.
No problem.
I'm good. Thanks.
Going back to the questions, I just stopped sharing. If it is a girl, who does the LLC consist of, Dr. Shah? LLC typically consists of a couple of district officials and then also one organization who's in the local, at the district level, been appointed as it's a local level committee. It's a committee of persons. Kritika Rajaram, if it is a girl PWD after parents, brother is a guardian, can his spouse become a primary guardian or only blood relative? See, this is what the application of the guardian, for the application of the guardian, like I said, like if it is a female, if the PWD is a girl, then they would approve, they typically approve a guardian to be also a woman. Okay, so I think in case the brother of the PWD, girl PWD, the brother, the brother's wife would normally be considered as the primary guardian. This is my understanding from what I have read in the national thing. And because I think this is to ensure, unless of course there's some reason to believe. I mean, they do believe that they cannot, the brother's wife, brother's spouse cannot take up the guardianship. If you have a disability card, can the PWD have an independent bank account, or it should be under the guardianship? See, this is again, a bank account is also a legal contract, opening of a bank account, and again in that case, like it should be a joint account holder, and the joint account holder should be a legal guardian.
Sonal has raised her hand. Sonal, please go ahead.
Thank you. I have two questions. One is,
Can't hear you.
can you hear me now?
Mm-hmm.
Huh? Yeah, sorry. So for the first question is, if the parents are still alive and they are not independent, if one of the siblings takes guardianship, do they require the permission of other siblings, or it's only the parental decision to allow them? How does it work, if you can help us with that?
Okay. See, when the parent is alive and you can apply for your sibling, one of the siblings directly. Yes, what it says is that jointly, they typically say if there are 3 siblings, then it is like all the siblings can take it up jointly. Yeah. If not, the other siblings have to be give this thing that they will not take it up. They are okay with one sibling taking it up or something. That's this is my understanding. Okay. But you as a parent, if you can apply for one of the siblings in the application and see what happens.
So you're suggesting that one parent and one sibling jointly apply?
No, parent and sibling, I'm not too sure on that. They say that parent means both parents or one parent. Or if it is sibling, all the siblings or any one sibling.
Got it. And does it change with the parents' demise? I mean, because the parents are old and they are incapable of. They are also dependent on the siblings, right? So does it change with any of those conditions changing, or it doesn't change much? Once you get a legal guardianship, that continues till the legal guardians are alive and healthy and able to take care of.
Yeah, see, again, you can always make an application. I mean, no certificate is like, I mean, there are always, I mean, it's not like it's, so you can reapply, and then you want to change the guardianship, you can make another fresh application.
Got it. One follow-up question, sir, on the trusteeship. What is more advisable, the trusteeship or just the joint ownership of any movable or immovable assets? I mean, we don't understand. That's the reason why I'm asking at a very high level.
See, trust is trust. The advantage is that the assets are completely protected in the name of the child. That's the advantage of it. So, and the trustee who is saying, I mean, is legally bound to use those particular financial assets only for the benefit of that particular person on whose name the trust is. So there's while it is joint, when it is joint, it is like, again, it gives a opportunity for any unfair practices, which is likely to happen. So that is something which you don't know. Things are very fluid. So to ensure that it's completely protected, a trust is I would advise a trust be created.
Okay, there are few raised hands also. So you can go ahead and ask, please.
Sonal, Shekhar. Sonal is done, right? Okay, Shekhar.
Yeah, so there was a question on the bank account. The banks require a legal guardianship certificate to open a under guardian account. That's what I went through. It's very clearly defined by RBI, and yeah, that is very clear. I opened it. I had to struggle for some time, but if you have a legal guardianship certificate, you can open an under guardian, and you are allowed to operate the account on behalf of the PWD individual.
Okay. Thank you, Shekhar. Thank you for clarifying.
Yeah.
Mr. Balasundaram, Sriram Narayan. Okay.
Can you hear me now?
Yeah.
Yeah, sorry, I was on mute.
Okay.
Thank you for your time, sir.
Sure.
I want to ask this question at a slightly higher stage of evolution. Some of us parents who are, senior parents, we've already done the guardianship, let's say 10 years ago or 8 years ago. So we have the form B. The local level committee has met. Me and my wife, we've gone and met them. You're right. They were only agreeable to me and my wife as the primary and second guardians initially. So to get a guardianship for the very purposes that Shekharji just mentioned. So till, my son was a major, I needed to continue operating his bank account. I needed to do a few things on his behalf to sign papers, etc. So the guardianship is helping me today. Eventually, when I have to think of after my lifetime or later life, I'm creating a individual beneficiary trust for him.
Sure.
That trust is going to have executive trustees and an administrative trustee. The property is going to vest there. The executive trustees will take, one of the executive trustees will be one of his siblings and will also become the legal guardian under that, the provisions of the will, which will create the trust after my demise. So I think one clarity that people could get is it is a journey. Guardianship before the child attains majority. What purposes does that serve? Guardianship after the child attains majority till the lifetime of the parent. And then eventually when the parent is looking at later life, what after me kind of question, when does a trust kick in? And one of the executive trustees becomes a legal guardian. Now that apparently is possible to write in a will. Now, like you rightly say, after my time when that will is being executed and the trust is created, the executive trustees are in place. For one of them to become the legal guardian, he has to pick up the certificate with my name on it, go back to a local level committee and say that, listen, under this will, I am the legal guardian now, so please nominate me as such. Worrying about that is what is perhaps leading parents to ask that, can I have a sibling as a guardian even during my lifetime, so that I am assured that there is continuity. I don't need a separate mechanism that has to kick in and make somebody else a guardian after my lifetime. So is there a way to address these questions under the National Trust Act? I'm also a chartered accountant, incidentally. Is there a way to address these questions to Delhi and say, these seem to be questions, can you give us a guidance on these? In which case that guidance becomes mandatory to local level committees.
I think we'll have to work on it separately, sir. So because how to take it forward to the National Trust. I mean, what you're talking about is going up to the National Trust and asking them to give some clarity and maybe provide some guidelines. I mean, because these are some things which they may not have thought of while framing the original rules and regulations. But now as things come into practice, I mean, a lot of other questions keep coming up. So
one thing you are very right about, and many other parents are right about, different LCCs seem to either, when you go and request them to add a sibling as a guardian, some of them seem to agree. Some of them say that, no, it's only the parents during your lifetime. You're right. Sorry, go ahead. I interrupted.
Yeah, no, that's right. I mean, so that's why there's always this ambiguity in respect of this. So I don't know, as accountants, as chartered accountants, I think we have been trained in how to find a way to, legally bypass these ambiguities and somehow get everything protected so that our need is taken care of to the extent which we look at it. I mean, that's the way we look at it. It's not that I say that this has to be done that way, but unfortunately the environment pushes us or forces us to look at it in that perspective.
Just for the clarity of parents, the only solution I have found, it's not a perfect solution. I have written a will which will create the trust, which will create the executive trustees, and which will create the administrative trustee. In fact, the administrative trustee, incidentally, is a corporate trustee. So the 3 executive trustees will be 2 independent people and 1 sibling. And I have written in the will that one of these executive trustees will become the legal guardian.
Oh,
now that is after my time. How actually it will be put into effect, God only knows.
Yeah. I mean, see, that's the best you can do. I mean, you've done the best which is possible. And I think my only suggestion over there would be that if you name it, then it makes it easier. Name the person who will take over as the legal guardian. It would probably make it easier to go ahead and get the legal guardianship. That's the only suggestion I can give, offer. Other than that, I think you've taken care of it the right way. I mean, that's probably the best thing.
In fact, I've done that. In fact, I've done exactly what you say.
Fantastic, fantastic. Maybe you certainly can give a lot more guidance to many more parents in how to go through this whole journey. Yeah.
I have a 27-year-old son, and we got his guardianship when he had turned 18. So that was 9 years ago.
Okay.
I struggled to get his UDID. I just got past that hurdle. Okay. Now I have a legal guardianship certificate, and that helps me with all his affairs, day-to-day affairs. I've created the trust which will vest the properties and his later life.
Fantastic. Fantastic.
That's about all I could do. Thank you, sir. Sorry.
Wonderful. Yeah, we were just looking at, okay, there were 2 people who raised their hands. I mean, yeah, DF 926239. Sounds like a prison number.
Somebody is asking your number for your number.
Oh, my number? Okay.
We have asked the 2 raised hands to unmute. Please go ahead. So they may be off screen. Maybe we can take a few more questions from the chat box. In the meantime.
It's fine. Yeah. Can parents directly go and apply for guardianship, or you have to go through an advocate?
No, you can. I think you find out who is the local level committee over there in your organization. Or typically there's a process. You can go log into the National Trust site and you can do it. In fact, they can, the whole process has been identified over there. Yeah.
Okay.
You don't have to, I mean, advocate, I don't think is required in this particular case.
Yeah, Mr. Harish,
can you share RBI guideline about bank account?
Sorry. RBI guideline about bank accounts? I'm not sure.
Yeah.
What's that?
Regarding what?
Yeah, regarding what about bank accounts? I mean, that would be easier to. Is it like opening of the bank account? Is it operating the bank account? Is it closure of a bank account? I don't know. Yeah.
Yeah, Dr. Ashok has asked, so maybe he can unmute and ask you.
May I ask my question?
Yeah, sure, Harish. I can't see.
Hi, Sriram. Thank you for your present. Thank you to the host of this program. Is it a simple solution to create a trust first where both parents are members and also the sibling and maybe either the parent's brother or sister or something are trustees?
Yeah, that is, see,
the legal guardian, right?
No.
Then in that process, the parent passes away, then the brother or the child or the parent's brother or sister also become trustees of the trust and they automatically take over?
Okay. See, Harish, there are 2 aspects to it. One is the trustee as creating the trust, all those, and having those trustee. You can have others as a trustees into that particular trust. But that is only for the protection of the financial assets of what you're leaving behind in the name of the child. Okay. What is required is that this legal guardian is let's take a very simple example. I mean, you and your wife have a property. Okay. Okay. Once you pass away, ideally the property should go to the next of kin, and that is your children, right? Okay. Legal heirs should take over the property if you have not sold it at any point of time. I mean, they become the direct owners of the ancestral property, right? In this case, to include the other person as a jointly as a deceased, okay, it would be easier if that person's directly the PWD cannot sign on that particular thing. The person will have to sign only under a legal guardian. Okay. Even if whether you name it in the will or not, I mean, there needs to be a legal guardian who will have to sign on that particular, on behalf of that person. Okay. Irrespective of whether that person is a trustee or not. Okay.
So, Sriram, if I understand you right, a trust cannot be nominated as a legal guardian. It has to be an individual.
No, not a private trust. No, certainly not. Certainly.
Okay.
Yeah.
So that clarifies that point. Yeah. Okay.
Yeah. Okay. Yeah. A trust is a separate entity. Legal guardianship is a separate entity. Both have to be taken care of in two different angles. There are two different people associated. Yeah. Okay. I think there's something related to the insurance. Family floater health insurance, where a child becomes 18 years and legal guardianship, which insurance company offers health insurance for adult with disability. As far as I am aware of, I am not sure if there are any insurance companies which offers any insurance benefit directly for the thing. I mean, they offer it only with the. This is a question that which did come up of late. Only the insurance companies have decided to include person with disability with respect to even after they are beyond major. They have been in a family floater plan, but what happens? Will they include? There are two questions associated with it, which I don't know. I don't have answers for it. I mean, one is like, what happens if the parent or anybody who is listening, would a legal guardian automatically get into that same plan, or will they have to create a new insurance plan, health insurance plan, which I'm not sure. I put the question out to that particular to my insurance agent, but I still haven't got a response on that particular thing. And let's see, it's a bit of a gray area. I'm not in that particular aspect. I don't know too much on that. Can one, Ashok Shah, can one take or make partial guardianship if PWD is capable of doing small transactions? See, sir, I think overall the mother law is very clear. Like autism, cerebral palsy, Down syndrome, they are legally not considered capable of making decisions on their own, legal decisions. It's not a question of transactions. I mean, that's something totally different. I mean, transactions, what you mean is that going to a shop and then buying something, and he knows like how much to change, to give, etc. That's not what we're talking about. Talking about the protection of his assets which are under his ownership. I mean, whether to sell, buy, keep, and if you have to sell, what is the price to be paid? What is the actual price to be paid? Is he competent enough to make those decisions? That's how they look at it. I mean, that's where it stops. Hello, sir. If parents are okay, can a sibling be a guardian by himself or herself when the parents are alive? This depends upon how the application has been presented. Okay. I think that's something which we've already covered. How can a guardianship be transferred to a sibling after the death of the parents? By a will, I think ideally that would be the best way to do it. UDID comes along with her disability certificate. Okay. So I'm not sure what the question is on that particular thing, Shekhar. So, do you want to elaborate on it, or shall we just leave it for now? I think we'll leave it. Thank you. Not able to unmute. Joint holder of property. Where do you get a decent disability? Thank you so much. Thank you very much. It's a pleasure. LLC is chaired by the for a clarification. can you share the RBI guideline about bank account? I'm not sure. Dr. Ashok, what were you trying to say in that particular thing? Specifically, anything specific on that?
There's a question, if I don't have somebody reliable as a trustee or as a guardian, then what is the next option? Any answer for that?
Very difficult, ma'am. Very, very difficult question. I think it's something which we have to look at it. See, I don't have an answer. Maybe you'll have to look at a registered institution. That would be an answer. Or anybody, any neighbor or anybody who's been with any around nearby who you think maybe you'll have to develop that. That would be another answer. Beyond that, I don't think I can. Harish, your hand is up again. Yeah. You want to say something, Harish?
No, I think.
Yeah, I had to get the permission to unmute. I'm sorry. So the question was, what is your advice to parents of minor children who are PWDs? Should they apply for legal guardianship right when the child is a minor itself, or should they wait for the child to come closer to being 18?
Very relevant question, because considering in the current situation, especially many parents who are getting impacted by COVID and they're leaving children behind. Many children are getting orphaned. So all those things are there, very relevant. I'm not sure whether the law side they have recognized a legal guardianship. Maybe something we can try out and then find out, because this is something which is important to. But by all means, I mean, anyone below 18, irrespective of whether it's a PWD or not, they are protected. They don't have, the parents are the first natural guardians. And in case there is anything beyond that, they look at it. I mean, the court will also can appoint. So, of course, I mean, it goes for me also as much as possible. I mean, as soon as possible, prepare your will and keep it ready, so that we don't know when we are going to get it. We don't know what's tomorrow holds for us. So, yeah, I don't have any beyond that, Harish.
Thank you.
I think we are done with questions. Have you replied to?
Yeah, somebody asked for my contact number.
Yeah, somebody has asked for your contact number.
I'll just
and also somebody has asked for Mr. Balasubramanian's contact number.
Yeah. Maybe they can, how do we share it? I mean, my number is
so you can we can type it out on the chat box, both of them. We'll do that.
Yeah, I have shared my number. Okay, one last question: is guardianship certificate valid across the country? Yes.
Sir, I've shared my number separately with Dr. Ashok, who asked for it.
Okay. Yeah, I think we can. I think we are done. It should be. We can close up now. Yeah, Sudipta, maybe one last question. Yeah.
Just a minute. We'll let her unmute. Just a moment.
Thank you very much. Yeah, I learned such a lot. My last question is, my son, who is a Down syndrome kid, and he is 19, has already opened a bank account jointly with my wife. Is that not allowed somehow? What do we do about it now? And we do not have, I was not aware of this legal guardianship thing. So we are not legal guardians in that sense. He's 19 and both of us are there. I thought it would be a good idea for him to have a bank account jointly with either one of us. So we did open it. What do we do now?
Nothing. You just go ahead, keep that account going. When you create a trust, you include that under that particular account. You change the name as that of the account of the beneficiary, or you close that particular account and transfer the proceeds into a new account under the trust. That's one option.
Or now, if my wife becomes, or two of us, both of us become legal guardians, it should be able to continue, right? I'm sort of a little worried about the fact that you said that actually a mentally retarded person such as a Down syndrome kid shouldn't have had the chance to open an account. You said something like that.
Only on his name, singly.
Oh, jointly is allowed, is it?
Jointly is allowed, certainly.
Oh,
certainly.
Okay. Yeah.
Jointly.
You said something about your son.
Yeah. So jointly is perfectly fine.
Okay. So
I mean,
right
now we have an account for my son, and me and my
But then
wife
you are a legal
started.
guardian, right? I am not. We haven't registered for legal guardianship.
That doesn't. I mean, see, that's what Mr. Shekhar was shared is that now if you want to go and open a new bank account in the name of your son, okay, the bank specifically asked him for a legal guardian certificate, even though he was a natural guardian.
Yeah. So what I learned, if I can summarize for me and maybe some like me who are completely new to this, or so basically you need to, as soon as possible, for somebody who is past 18, get legal guardianships in the name of the parents. Then it's good to have a will which states who then becomes the next legal guardianship after we pass away. And also to have a trust separately in that will, either set up now or in the will set up a trust or something like that, so that when we pass away, then the property goes to the trust and the trust knows what to do with the property. And one of the trustees should be one of these legal guardian. Is that roughly?
Preferable, yeah. That is better to have it in that, keep it in that way, so that it sort of like ties up, you're protected from all sides.
Okay. And the trust can be set up as a will and somebody sets it up after our death, or should be set up before?
No, there are two ways of trust. There are two ways of setting up a trust. You can set up a trust now, okay, and start depositing the monies into it. But the trust will become operational only after your demise. In the sense, like, what are you're going to collect some kitty amount in it, okay, right now. Okay, once you start collecting and then why do we need the trust? We need the trust actually to pay for his expenses, to pay for any other additional costs, to look after his. Those are the areas where the questions will come, because that's when the trustee starts using the particular trust to operate on it. That's one way. The other one is that, yeah, you can have a trust. I mean, ready. I mean, you can still have the trust operational from now itself. But ideally, what they're looking at is that they would, then what happens if once the trustee, the question is, the biggest thing about this trust thing is that, is it an irrevocable trust or a revocable trust? I mean, can it be closed, or it can be by any act, or is it until the lifetime? So specifically in the trust, what we say is that it is alive during the lifetime of the beneficiary. So it will be there available. And after that, what happens? I mean, we can also state over there in the trust deed, so that the monies which are collected can go into some other place, or whoever is living can take care of it. I mean, after the demise of the beneficiary. So that would be the best way. But that's a topic on its own. Trust itself is a topic on its own.
Hope you talk about it sometime. Thank you so much.
Yeah, sure.
Appreciate it.
I know there are quite a few people whom around here. Mr. Balsundaram is there, who's also there. Quite a few people who have gone through the journey, and they would love to share their Shekhar. Yeah, I'm sure others are there. Okay, great. Thank you all. Thank you very much. And think as I hope we have either kindled some thoughts or maybe given some clarifications or whatever it is. Either ways, take it in a positive note. And I also learned something as during this particular session. So thank you very much once again, Dr. Madhavi and
Thank
Arpita.
you so
And
much.
thank you.
Yeah, I'm sorry. Thank you so much, Sriram sir. It was a huge learning, I think, for us on the team and for everybody here. Thank you all so much for joining us. I think what I would like to say here is we would like to take up, this thing as a discussion going forward. I'm sure in a few weeks we can come back and have a panel. Mr. Balasundaram was here, Mr. Shekhar who's here. We can have Mr. Sriram back and have it as a panel discussion answering questions, because I think now that people have started thinking about it, I think more and more questions will come up, and hopefully we can help smooth that process. I know there are a lot more questions, but I think we're sort of run out of time, so we will come back in a few weeks for this discussion. So thank you so much, Sriram sir. Absolute great points, great learning for us. Thank you so much for taking time out and joining us. And before we wind up, just some quick information. This Sunday, we have a session coming up in the Mitra for Life Dads Club, which is financial planning for families of special needs children with Mr. Jitendra Solanki. So if you have all joined the Dads Club, you'll get the link there. So and just to be diplomatically correct here, we will bring him to the parent forum. We are not trying to leave mothers out. We'll definitely have him back for a general session in a few weeks. And yes, thank you all so much. Just to let you know, Mitra for Life meets every week on Thursdays, and this is what we do: community discussions. It's an open forum. Once a month, everybody can express their views, and we'd love to have you join us. So we'll just play a short clip of our work before we wind up. Thank you so much.
Thank you.
Thank you all so much. Have a great rest of the evening and rest of the week. Thank you.